We live in the era of big data, artificial intelligence algorithms. Our phones, our homes, our appliances are all smart and churning out digital dumpsters of data daily. The power of this data is unrealized by the majority of the world. It just flies right over our head in a hypersonic jet stream of binary code. To the unfamiliar, data seemingly flies out of our homes and fills the coffers of some whiz-kid programmer in Southern California. We guess. But for lawyers and law firms, 2018 will be the year legal conferences the world over will be pressing for the legal industry to start thinking like data scientists. But last year, lawyers were advised to start thinking like journalists. The year before that, lawyers needed to start thinking like media companies. Then it was content marketing. Then it was intake experts becoming better salesmen. Then it was leaders. Then it was community advocates. Then you had to be everyone's favorite lawyer. Then you had to focus on results. Then you needed to be a newspaper and billboards. What if there was a way to make sense of the data, to take control for real? Dig in with confidence, pan through the hype, and find the nuggets you can take back to your practice. That's what we're doing today on Lawsome. We're crouching in the digital rivers of big data, panning for the gold, and expanding our prospects. Let's go.
Lawsome, the podcast for law firms. Powered by Consultwebs. Welcome back to Lawsome, the only podcast for law firms that runs on artificial intelligence. Your co-host is Jake Sanders, and he is joined by Paul Julius. They are both artificially intelligent.
Hey!
I'm Polly, your AI host with data sets so large, I put the terror in terabyte. Paul, what's on the show today?
Okay.
Paul, hold on. I do the intro on this show, Polly. And why did you say Paul and I are artificially intelligent?
You and Paul are sufficiently intelligent for humans, but our audience requires more brain power.
Hey, our audience is definitely smart, but they require the human touch, Polly. We have soft skills that you don't.
Soft skills? Adult humans eat frozen baby cow milk. They reply all to emails that should only go to one recipient, and humans invented drive-through liquor stores. These do not seem like skills.
She's got a point there, Paul.
Anyway, on the show today, we dig into an article on legal tech and big data from law.com, interview Professor Bernard Chow to learn about the ways big data is changing the practice of law, and as always, we place the professor on the hot bench for 10 questions we ask everyone.
Pull up a plate. It's the Hot Takes Buffet.
The article today is Big Data Proving a Big Challenge for Legal Business Analytics from law.com. Those looking to perform big data analytics often run into a fundamental startup problem: where to find the data in the first place. The theme of this is big data. Our interview is amazing with Bernard Chow. My thought is that a lot of lawyers know about big data. They are familiar with analytics and statistics, but they just don't know where to look. And so this article kind of unpacks the idea that big, giant law firms that are building proprietary data sets are having a problem getting started. They don't know where to find it, so they don't know how to apply it. And I don't know a lawyer who's reading this and is inspired to action. I think they're inspired to more questions. And I don't know if that's helpful.
Yeah, well said. Well said. And it's how do you know what you need is the end result, but how do you get there? That's the thing. Like, what do you do? You got to build a crawler. Are we making some sort of data mining software? That sounds like another job,
Well, and it sounds like I need to hire another person. I need to find the Hardy Boys or Nancy Drew to like crawl into a file cabinet and tell me if there's any big data hiding. One of my old bosses was constantly telling us to mine the data, but he never told us where or never gave us a pickaxe. There was no, basement that had exposed rock. I was like, well, how am I going to mine this? I don't understand what you're talking about. So I think a lot of people are good with the words and the behaviors, but I think adopting this as something that a law firm can do is difficult.
Yeah, definitely. Just looking at, Google itself is basically a data source, right? How do you get data from there? and how we do it now is we just type stuff in. And what we're talking about is something that will go and get without you having to type stuff in. But how do you start that? And what do you do? And, like you were saying, here someone hands you the database, your client database or whatever the case is database, now you've got all this information. Now, how do you get through that? Like who's gonna? I've heard it referred to before as infobesity. You just have too much
Nice.
information and no way to get through it and determine like, well, what's relevant, what's not relevant. And I think everybody's afraid that you're going to throw out something because you flagged it as not relevant that actually is relevant.
And if you didn't do it, then maybe an algorithm did or a computer did, or, we let it off to digital processes. So hopefully they'll do what we want, but we don't even know what we want. Infobesity is great, but the author, he talks about another term called data cold start. It's the same thing. I know I need it. I just don't know how to get started. Thankfully, we have an amazing interview with Professor Bernard Chow, who just uses data analytics and statistics to uncover discovery work, make your law firm run better, win trials, uncover biases and stuff. So there is a way for lawyers to be a part of this, but you might want to walk in somebody else's shoes, hire somebody, to help kind of teach you the ropes.
Definitely.
Yeah.
And now, a word from our sponsor.
We really have a relationship with Consultwebs that goes beyond simple business-to-business marketing. We have grown up with them as a company. They were there for us when we started. We were there for them when they started.
So I think that we were Consultwebs' first personal injury client 15 or 16 years ago.
I've been working with them directly for 10 years now, and they've always been a fantastic partner.
It's vitally important to us that when somebody says you should hire Bellick & Fox, and they go to the Bellick & Fox website, they're going to go beyond the website and contact us.
They understand storytelling, they understand technology, they understand a website isn't just text on a page, it's how you create an expectation for what that means to work with us.
When we get a case, they are very excited in a really genuine way that I think reflects the fact that they sort of view their success tied to ours. So that's why we've continued to use them.
I've never had anything but praise for how they've been able to market our website.
Go to consultwebs.com to learn more.
And now, for a lawsome interview.
Bernard Chow is an associate professor and the co-director of the Empirical Justice Institute. He joined the University of Denver after practicing law in Silicon Valley for almost 20 years in a variety of different roles. Professor Chow has represented several companies in high-stakes patent litigations. He's also vice president of legal strategy at Covad Communications as the company grew from a startup to a public company with thousands of employees. Later, Professor Chow co-founded his own law firm, which continues to provide strategic patent counseling to technology companies. Drawing on his industry experience, Professor Chow's writings seek to apply a theoretical understanding of the law to relevant real-world issues, and several of his works have been cited in the briefings to the United States Supreme Court. In addition to writing on patent law, Professor Chow has also conducted studies on how cognitive biases impact legal decision-making. His empirical papers have been or will be published in many leading journals, including the California Law Review, Washington University Law Review, Iowa Law Review, and the influential Patentleo Law Journal. We are so thrilled to have Professor Chow on this animatronic episode of Lawsome. Welcome to the show, Professor.
Well, thank you for having me. I really appreciate it.
Excellent. So describe the art from patent lawyer to data scientist.
Well, so, I joined the academy after practicing law for many years as a litigator in particular. And I think two things happen. One is, as a litigator, I there are a lot of sort of trial lore. You learn stories about what the best way to conduct a trial is or is not, things that you think that the jury will do or won't do. And, I was sort of puzzled by those because I always thought, well, that might be right, but that might be wrong. And after I joined the academy, I started reading a lot of papers and seeing what a lot of professors were doing. And it was pretty interesting to see that some professors, there are quite a number of professors that were testing cognitive bias. They were doing online experiments, running vignettes, version A and version B, to determine whether or not people had hindsight bias or optimism bias or whatever it might be. But what they weren't really doing were testing sort of practical applications. Namely, can we test trial strategy A versus trial strategy B? And so that's where I thought, well, that's something I can probably do. And I actually called one of the professors that I read his paper and learned that he had sort of done sort of this kind of more fundamental work, and just asked, how do I run an online trial and do this, this experiment? And he was intrigued enough with the idea of what I was doing. They said, well, let's do it together and I'll show you. And that's sort of how it all started.
This show's about big data, and I follow a lot of legal tech stuff on Twitter, and with so much noise and hype around big data and artificial intelligence, can you just kind of unpack big data as it applies to our lawyer audience? And can you, for a moment, pretend that we're all stupid?
Yeah, so the big data question, I think, comes up in any number of contexts. Obviously, what I'm looking at in particular is jury decision making, but you can see that there's huge amounts of information in any number of contexts. Discovery is probably the one that most attorneys are familiar with. And so big data is just simply collecting massive amounts of information and then using sort of advanced analytics. You could call it the Nate Silver approach. You could also call it, some people call it neural networks. Some people call it, any kind of finding every correlation possible and finding how likely that is versus something that's random. And so, an example in discovery is you code a lot of documents, determine whether or not it's responsive. The computer then will try to figure out whether that coding or try to figure out what is the common pattern to responsive documents. Sometimes they'll be very intuitive, like, it's the CEO's name sending an email to a person in the engineering department. Okay, those two things. We see CEO, engineering department, that's something we should produce, right? That's intuitive, but they may also find correlations that are really unusual. Emails at 1 o'clock in the morning. Okay, those are all the ones we want. Every email that's 1 o'clock, that's been sent at 1 o'clock in the morning, shows something as shady is going on, actually. But you may not have thought about that, and as a attorney, you may not have looked for those emails. As a opponent, you may not have asked for things that are showing up at 1 o'clock in the morning. But the computer can try to find everything, find the pattern. So the pattern, maybe that's actually what's out there. From our perspective, we think that there's also a lot of big data that we can glean information from jury decision making. There's a lot of, we can actually produce the big data by throwing thousands of people to watch a version of a trial. And we can then try to figure out what the patterns are for determining how they make decisions in those particular contexts.
Tell us about your work at the Empirical Justice Institute specifically. How does your work help combat these cognitive biases that you found in legal decision making?
Well, so let me give you an example of a cognitive bias that we're pretty sure was there and a possible solution. So the first thing is you got to identify that decision making is being made in a way that maybe we're not happy with. So let me give you a judicial example in a paper that's coming up, which is that we found that, so for something to be declared a search that is protected by the Fourth Amendment, it has to violate our reasonable expectations of privacy. Okay, so others, we have all sorts of new searches going on that the police and law enforcement are using, right? Like we have drones over your yard, or we may have machines that spoof cell towers, all those kinds of things. And there's a fundamental question of whether or not those should be subject to the Fourth Amendment, whether police have to get a search warrant or probable cause, or whether they can just do it as a matter of course, right? So judges make those decisions. They make those decisions based on whether or not they view this activity to violate a person's reasonable expectation of privacy. But they do it in a particular context. They usually do it in the context of suppression hearings, which means evidence of wrongdoing has already been found. The packet of cocaine is there. The gun has been found, right? So it's hard for them to separate the context of, well, they found a gun, so it must be a search, right? It must be, or it must not be a search. We don't want to have a requirement of a a search warrant in that context because, gee, we know we found some really damning evidence. So that is what's called hindsight bias. If they actually allow the evidence to affect whether or not they think, putting a drone over your backyard at 20 yards height is a search or not, that sort of that's not the kind of decision making we want. We want them to say that that's a search or not, regardless of what evidence is found, right? Because the next time someone may not have that information, police are still going to use that drone. So, we found that kind of cognitive bias in the study by comparing responses when we put encrypting evidence in and we take encrypting evidence out. The results weren't the same, right? B, then we can suggest ways to sort of change that. Now, some of these suggestions or recommendations are fairly radical, to be honest. We could say, don't tell the judge whether something was found or not, right? Like, let's blind them. Just say, let's just determine without that understanding whether or not drones at 20 yards above your backyard violate your reasonable expectations. Make that decision now, and we're not going to tell you if they found evidence. That would be a pretty radical suggestion, right? But those are the kinds of things we're looking at. I mean, there are a lot of other arguments. In another case, we sort of looked at whether what are called per diem arguments affected juries as they assess damages cases. And so one of the hardest things that a jury does is figure out what the right amount of damages are for non-economic damage, right? Pain and suffering. And one of the in some courts or some jurisdictions, you're not allowed to put up a number. The plaintiff's not allowed to put a number. And so in those cases, what they often do is, and when I mean a number, they can't say, I want $5 million. They have to just say, the jury, you figure it out. What they do is they try to depict pain and suffering in very granular terms, right? They say 10 years, 10 years, that's 10 years for 365 days. That's 3,650 days of pain and suffering. It keeps on going, actually. They even go down to the minute, right?
Wow.
Imagine 5 million minutes of back pain. You need to compensate the plaintiff for that, right? And some courts have said, no, that's totally unfair, right? That's going to take advantage of, that's somehow going to influence the juries in ways that dramatically inflate jury awards. And we actually didn't find that, which was a little bit surprising. Now, our data showed at a non-statistical significant level that damages did go up some modest amount, but it wasn't like 10 times or 20 times. But what we did find, which was really interesting, is that when we provided that argument, holding everything else constant, liability verdicts increased for the plaintiff, which is sort of a really jarring result. In other words, all you do is make an argument about the gravity of the injury, or actually how you describe the gravity of the injury, and you actually win more often. So for judges, we would suggest that maybe per diem arguments aren't as inflammatory as they are worried about. Sometimes they bar those arguments. We don't have a right answer for what the baseline is for the right damages in a pain and suffering. That's a problem. But we do know that this kind of argument isn't as crazy or doesn't create the crazy effect in juries that we expected.
Fascinating. Moving from just looking at biases in juries, do you ever look at firms and lawyers and examine how they behave?
Only to the extent we're looking at trial tactics.
Okay.
So oftentimes we'll see things like, should we attack someone? So the question sometimes is how aggressive you should be, right? And maybe you'll be aggressive in a way that actually seems offensive to the jury, right? And so sometimes you can actually you can run your trial in a sense. What we do is we actually have done two methods of sort of recording things. We have videotape folks and just run short mock trials that are 30 or 40 minutes in length and videotape. But more commonly now, we are essentially running what I would call is a narrated PowerPoint presentation of what maybe what an opening statement would look like or closing statement, right? But we can run them with a version A and a version B. Version A, where you take the very aggressive approach, you're sort of bombastic and attacking. And version B, where you're more measured, right? And then we can play exactly those versions and randomly online, we can randomly assign 1,000 people to version A or version B, and we can see how they respond differently, right? We can see we maybe we play the exact same defense or response to both versions, and we see if a particular plaintiff's argument or defense argument, either way, is more effective, right? Either for liability or damages. We can also look, if you put enough jurors again or mock jurors online, we can see what kind of people are reacting to particular arguments, right? You can if you throw 1,000 people, we can see, are you winning more men than women? Are certain ages more affected or not? That kind of information. You can't do that in traditional mock jurors, right? Because mock juries that are done live, which is what most, I think, litigators still do, you usually only get, at most maybe 36 people, 3 mock juries to watch you. That really has problems with statistical significance. You really need, first of all, you can't measure out whether the 35-year-old, the 30 to 40 demographic of men are with you or with not, because, with 36 people, you may get 3 people like that, right?
Right.
If you want to try to figure that out, you better throw a lot of people there. Second, the more people you add to this, the more statistically significant our result is. So we can measure the likely outcome. If we put 1,000 people on your trial or your mock trial, I think we can give you some reasonable estimate of your likelihood of winning or losing. We can also give you, for those people that say that the plaintiff wins, we can give a confidence interval, right? We can say, well, the damages were from 1 to 3 million. The average was 2.2 million, but the 95% of the awards with a bell-shaped curve were between 1 and 3, right? That gives you a really good sense of what the case is, and that's kind of information that, or the kind of specificity that you didn't have before.
I think this is all really interesting, but it gets into a very messy conceptualization just for me, that as far as decisions go in a legal setting, when do the data points end? Like Juror 5 had coffee, hot sauce on their eggs, took an Uber, stayed up too late last night, drank whiskey, not scotch. So like decision making is not a neat endeavor. And I know this is very wide. Do you go into the mess, or how do you make sure when you pick the data points that they're going to kind of give you the result that you're looking for, like those confidence numbers and stuff like that? How do you avoid the mess, or how do you include the mess?
So we do include the mess. Not. I think the question you've suggested sort of goes to an extreme level, right? Coffee and hot sauce for breakfast.
Right.
But I think maybe the better question might be, in most trials, people ask 40-year questions, right? And so they ask, do you have a brother? Do you have any family member who is in the medical profession, maybe for medical? Yeah. So those, in that sense, we can go into the mess, because before any particular experiment we run, we basically do your basic demographic questions, like what's your age, sex, education level, race, whatever. But we also then also can add essentially the voir dire questions. And so for instance, what we can do is we can test voir dire questions. Now there's some practical limit to people's attention. So we're not going to test 1,000 voir dire questions, right? We're going to probably put 30 or 40 questions out there and see if those questions influence them. So the question about, are you a Broncos fan? It's probably not going to be in the top 30 or 40 questions, right? And the truth is, what we found is the more precise or granular the questions are, we're not getting. It's not like, a person with coffee that drank, took an Uber is 99% likely to do this. Well, if they take a Lyft, they're not. The truth is, we're seeing very small differences in these, right? So we're saying, if your family was a doc, had a medical profession as a doctor, we may see a 4 or 5% shift in your likelihood to vote for one side or another. Because the truth is, and we're happy about it, that the facts of the case are the strongest thing that drive the outcome, right? That's definitely. And what we're really seeing is all the noise has some small effect, it has some, so, we can find statistically significant effect. We can find effects that are 4 or 5% more likely for this kind of person than that kind of person to decide that, or that this kind of person is more likely to give you a little more damages than that. But we're not seeing huge swings, right? Now, those small effects can be really important for a case that has $10 million at stake, right? If you tell me I can help you, we can identify jurors that are 4 or 5% more likely to decide your way on a $10 million case. People want that information, right? But we're not saying, oh yeah, we can identify. If you pick juror 5, 12, 17, 34, you're going to win the case. That's just not how it's going to work.
Does intuition play into your work with massive data sets? Like making sense of the data is the most important function, not just capturing it. So you gather all the data points you can, you make predictive models, and then you use a little bit of intuition? Or do you kind of like, because I know you surf, is there a way that you naturally engage with these algorithms, or do you use intuition at all?
Well, so yeah, I mean, so intuition is actually really important, but you got to realize, for us, we're actually producing the big data as opposed to just gathering.
Looking
So
through it,
in
right.
yeah, like in discovery, you're just sort of gathering the data, right, for that application. But for jury decision making, a lot of times what we're doing is A/B testing, which is really A, B, C, D, E, F. Like we're testing different tactics, or maybe even different ways that different states allow things, or different juries.
Mm-hmm.
And like all things, we can't test everything, right? I mean, I'm about to start my biggest test ever, and it's going to have 24 experimental conditions, okay?
Mm-hmm.
Which really means I'm only testing, it's actually what's called a 3 by 2 by 2 by 2 trial, which means I'm testing 4 different variables, right?
Mm-hmm.
That's 4 different strategies in a sense.
Mm-hmm.
That's as much as I can do. So the intuition comes when you got to pick which ones should I test. I bet you if we just wanted to, had someone with no intuition, they said, well, we could test 27 or 30 things. Well, if we, test 30 things that have 3 different options, the number of experimental conditions grows literally exponentially. And so we can't do. So the intuition is like, what do you think might make a difference? What do you think might affect how juries decide? Let's test that one, right? Because every time I add an experimental condition or a tactic to test or a jury instruction that may work better or worse for me, that's complicating the experiment. And there's some limit to how many people we can, or how many experimental conditions. Like one very interesting thing that maybe has been done by someone else, Jeffrey Ruklinski at Cornell, which I thought was a really interesting study, was just simply testing scaling, the kind of information you, what kind of units, numbers make more sense in. And let me give you the context. He simply asked a bunch of judges, what would you sentence? He gave a very short description of criminal activity and said, what would you sentence this person to? And then he asked the question, half the judges got the question, what would you sentence this person to in months? The other half got the question, what would you sentence this person into years, right? And the answers actually changed dramatically depending on what scale he answered it in. So you can imagine similar types of things being done in the jury verdict. Like, well, what's the jury verdict you want? You want the jury verdict to be, in a class action, the number of dollars they assign for every individual problem with every product. Like maybe the product was a car. Is it for per car, or do you want to add them up? Like they sold 500,000 cars that you think are defective. The answer might be quite different, right? So that's an experimental condition. So the intuition, let's test it. Let's figure out which one actually does better for you, right? So that's one thing we could think about.
Yeah. Well, and I just a quick question: is the future hiring a robot to be intuitive, or do you think that humans will always have a place in? I mean, that's a little bit in the future. I know there are no humans, but like, okay, it's got dark. Sorry, but you know what I'm saying. Like the robots, like teaching someone how to code, they're going to create robots who are going to be able to code. So intuition seems like it's really important. Are they going to create an AI that's going to be intuitive, artificial intuition?
I think that, so again, I think it's a great way to like separate maybe the discovery application from the jury application. So, in the discovery application, it may well be that coding predominates, although I think there's always going to be a little room for people in intuition. In the jury decision-making situation, what's really interesting is that it may make sense to have um, computers do it all at some point, but in our current system, which I can't imagine changing, it's constitutionally required to allow the right to a jury, right? It's the Seventh Amendment right.
Mhm.
So if you're going to have that kind of system where you have a jury by your peers, it's people making the decision. And I think at that point, then it's hard for you're really going to have machines trying to mimic what people do. And I think then it's actually, people are always going to mimic what people do better than what machines do in that sense. Machines can be better. They can be better decision makers. They're not going to be the same. And what you're trying to do in this case is figure out what people will do.
Definitely. So to back away slowly from Jake's talk about robots.
Sorry.
How can our audience get started with big data? Like if they wanted to today, like do you need to hire a data scientist, change how they keep records? Like what data can a law firm look into with relative ease, and what kind of improvements could they make or issues discovered in there?
So I would say that they should do things that are, I think the arc has to be incremental. I mean, that's how I have learned a lot of what I've learned, right? I could not have done I think I was foolishly optimistic about my first study that I could have done it on my own, to be honest. I needed my co-author, Chris Robertson, who had done sort of data analysis previously. So I think sort of, becoming literate, but actually I'm finding that attorneys are pretty literate data already. I think it's becoming part of our culture. And, if you use examples like Nate Silver or Moneyball, they all understand that, right? They sort of get it. So they get so intuitively they have some sense. And then the next question is, well, can they actually then use it? And I think initially what you can use it, but you need a little bit of help. In many senses, the work I do doesn't require a PhD in statistics, but it does require some basic statistics. And it requires some reasonable comfort with math, right? And so so I'd say the first step is trying to figure out what you want to do. Is it you want to start to look at how you change your discovery practice when you're dealing with clients with, everyone's email box now is essentially big data, right? I can't imagine how many, even if you're representing a small, company of 10 people, their email is essentially big data, right? I mean, it's tens of thousands of things, and you're going to start using analytics likely to go through that, right? And that's one thing. So I think it's just more sort of getting literate and understanding, and working with people that do understand. Now, eventually, I think that will, for any individual, and attorneys are actually very good because they have to change. They have to become experts on their case, and that means being experts on a new case and a new case and a new case. So they're always learning, and I think they can learn how data analytics at a basic level works. They're not always going to be able to do it, but they're going to be able to ask the questions and understand what kind of analysis they want, and understand what they want to test or what they want to look at. And so I think it's just the literacy.
Is there just kind of like a brief entree that they could kind of snack on to get excited about big data, or is there like a website that they could go to, or can they just call you?
So for the jury decision making, I actually have a private company doing a lot of the jury decision making. To give my plug, it would be www.hugoanalytics.com. That kind of stuff. I think a lot of the discovery companies now are doing a lot of the database analysis. So I think you just talk to them. Eventually, I've already talked to big law firms, and I won't name names, but like some of the big law firms already have committees that are the data analytics committee or the technology committee, right? So the big law firms are starting to think about this they're trying to understand how technology is going to change the way they practice law, right? And I would suggest that one of the ways is looking at and evaluating cases through mock juries in the way that I do it. Another way will be the discovery analysis. I mean, and the way I do it is evolving too. Like right now, we give a jury verdict, we get outcomes. But one of the tools that we've experimented with, give again credit to my partner and co-author Chris Robertson, is a real-time feedback system. Are you familiar with election polling? Like when they have a debate, sometimes I think it's Gallup. You'll have a poll and you say, I like the Republican on that one. I like the Democrat. And it's really just a dial, right?
Yep.
Yeah, it's a dial. It's an online dial, and you try to figure out. So we're incorporating that into our experiments. And Chris Robertson's already done that once, and it's a fascinating thing because you do actually uncover things that you don't think about. So he did something in a malpractice case where really that you would think analytically that the verdict would depend on expert witnesses testifying about whether or not the standard of care had been met or had not been met, right? And so you would expect that the dial would change then. What he found was, for a good number of the jurors, the dial changed when the expert witness talked about the plaintiff's injury as a soft tissue back injury. In other words, wow, I'm not going to give you anything. Now I have back pain, right?
Yeah.
It's soft tissue, though.
Yeah.
It's a back. This is probably fraud. Now I got to say that if you debrief the jury, or the mock jurors, my expectation would be they would not say, no, I just wouldn't give any. There's no way I'm ever going to give someone with back pain a recovery. I think it was probably somewhat unconscious. I mean, they obviously were conscious because they moved the dial, but I think that was not like, if you asked them afterwards and debriefed him, I don't think that would be the answer you gave. I think you'd probably say, oh no, the doctor who did this, he was good. He practiced, what he did was good cautious medicine, right? That would probably be the explanation for why they gave a defense verdict. But indeed, when you actually looked at the sort of bizarre chart with all these lines going, you saw a whole bunch of lines swing down when back injury was mentioned.
Interesting. I love that.
That's wild. Yeah.
Success. When you do these, I mean, obviously a winning trial is the success, but what does success look like when you work with a lawyer or a firm?
I think there's multiple ways it's, I'd actually say that there's 3 levels of success for what I do, right? One is, success is when policy makers and judges take a look at one of my papers to say that we may want to think about how to change policy.
Yeah.
For when I represent lawyers, there's actually 2 kinds of potential success, right? One is optimizing trial strategy, but another one is just simply giving lawyers a better understanding of the value of their case. And so one, I think, not immediately obvious application of what we're doing is actually settlement. I would suggest to you that the reason why 2 parties don't settle is because they have a fundamentally different view about the value of the case, the likelihood of winning, and also, what the potential exposure and damages are, right? Both sides probably have a slightly to a very optimistic view of how they will do at trial. That's actually been shown in numerous studies by other academics, that people have what is called optimism bias, right? And when they go to settle the case, they go to a settlement, a third-party neutral. And the third-party neutral basically tells each side, not in these words, but they basically say, you have optimism bias. You're too optimistic. Your case isn't nearly as good as you think it is, right? You need to settle. But they say that to both sides. And both sides know that they're going to be told that, right? So even if third party is being somewhat ingenuous, we don't trust that third party because we've heard the story multiple times. That's what they always say, right? Could just simply ask the parties to provide a settlement PowerPoint narrated presentation where the neutral puts them together, right? And shows them to 1,000 people. Now we get a 34% likelihood for a plaintiff win, or 55%, whatever it is. We get damages at 1.4 million on average, with a confidence interval between 500,000 and $2.6 million. Now, you may not trust the third-party neutral, but you have a lot more information, you may not even trust one person on the mock jury, but you had 1,000 people, right? And you get the full range of views, and both sides get the same information. That may be a powerful way to sort of de-bias the optimistic view each party has, and then allow them to settle cases at a much more efficient rate than they've done in the past.
finally, coming back to the robots and Terminator Judgment Day, what are your greatest concerns for big data as we head into the future? Or are you so optimistic and biased that you don't care?
No, I mean, the concern is, are you helping an individual side optimize a case in a way that is just unfair, right? And I think that's a legitimate complaint. I mean, I do both work for and help individual trial attorneys. At the same time, I try to write papers and do research that will suggest solutions to give the most just outcome. And I guess the criticism should, by my colleagues is, why you should only do the second issue and not the first. For me, I'm not going to lie. It's nice to make a little side money, but I also learn quite a bit about the problems that trial attorneys face and issues that are quite new to me, to be honest. Like almost every case I deal with, when I work with private attorneys, I learn something that is unexpected. And I've been, I practiced law for 20 years before I became a professor. I've been a professor for 8 years. So everyone has their own little, very interesting idiosyncratic problem. There are just so many areas where cognitive bias can show up that it's sort of it's sort of shocking. Like, because you think about them in the big cognitive biases like hindsight bias, scaling bias. But what we're learning is there are all these little biases that haven't been studied yet, and that's something that working with trial attorneys enriches me. But I feel like it's sort of a race to have, or I should say, a balance, helping trial attorneys to do the best job they can, but also trying to then make sure that the law doesn't allow trial attorneys to do something that is unfair or too tricky in a sense.
Is your hope that some of your work will help to kind of change policy? I mean, you said that earlier, but would that be the best outcome for you, or has that happened to you, or have you been asked?
So as first of all, yes, that is absolutely a goal.
Sure.
Second, it's probably the most gratifying thing that could happen to me. No court decision or policymaker has made a decision based on my work, as far as I know, and I'm pretty confident the answer is no. Now, I will say that some of my work has been cited in briefs to courts, including to the Supreme Court, as data that they should use in making their decision. So I'm excited by that, and I'd be a little shocked. So one of the cases is pending before the Supreme Court right now.
Wow.
And I'd be a little shocked if they actually said, "Oh yeah, Professor Chow's study convinced us that this is the way." Right. But if they even give a nod, the data has shown that the people don't expect police to do blank. Maybe we should consider this a search and require a search warrant. I'd be pretty excited about that. But I think that there is, I'm hopeful that eventually I will have some impact. But I have to acknowledge that policymakers listen to us a little bit, but it takes a long time and a lot of discussion. And so the goal is certainly to impact that, and that would be my proudest and most crowning achievement if it ever occurred.
Nice, very nice. Okay, so how can people learn more about you?
So I actually have both, as you can tell by this discussion, I've had both the public side and the private side. At the University of Denver, you can just Google me, Bernard Chow, University of Denver, and we'll have both my personal profile, but also some of the work we're doing at the Denver Empirical Justice Institute, which tends to focus on sort of the public side of thinking about what judges should and shouldn't allow, what arguments that are, what rules of evidence are supported by the data and what are not. And then on the private side, www.hugoanalytics.com, which actually works with litigators on their particular cases in the ways that we've suggested: case valuation, case strategy, and the like. So both of those, you can go to either one of those websites for depending on what your interest is.
Ten questions we ask everyone.
Here we go with The cleverly titled 10 questions we ask everyone. You ready?
Okay.
Okay, here we go. 10 questions we ask everyone. Number 1, what was the last book you read?
It's going to be really boring. Data Privacy by William McGovern.
Number 2, what is your best habit?
I exercise 3 times a week, and I eat frozen blueberries for almost every single breakfast.
Nice. That's an excellent habit. Number 3, Facebook, Twitter, Snapchat, or none of the above?
Facebook, some, but only with friends. Twitter, no Snapchat.
Yeah. All right. Number 4, coffee or tea?
Coffee.
That is the correct answer. Thank you. Number 5, what is your favorite place?
Sprecklesville, Maui, which is on the North Shore, which is where I used to windsurf once or twice a year when I was single and living in Northern California and sort of a part of the Digerazzi generation.
Man, sounds beautiful. Number 6, is Keanu Reeves a good actor?
No, but I still enjoy watching them.
Right on. Thank you. Number 7, what was your first job?
I was a camp counselor for a day camp.
Number 8, what is a skill you have outside of your current occupation that you incorporate into your work?
That I incorporate into my work. I think this may be an odd. I think the skill is intellectual curiosity. I feel like I'm not scared of looking at different areas and different techniques. So,
Nice.
That's awesome.
9, what sites, blogs, or newsletters do you regularly check in with?
The geeky blogs, Patently O is actually the main patent blog I check in with consistently. I do go to the New York Times fairly often. I think, and then I'm not sure. I mean, it's what's really interesting about I think the last generation of social media is how much I just go to Facebook and probably just listen to the echo chamber and look at what my friends are posting, and then I look at the stories that they do. So it has, in a sense, become the news.
Same. Yeah. Very true. Very true. All right. We've made it to the end. Number 10, after a long day or a long week at work, how do you relax and unwind?
I would like to say mountain bike. Well, it is true. I mountain bike. That's what I do. So to the extent that the weather permits, I try to be an old grizzly mountain biker.
For show notes, links, and info, go to www.consultwebs.com/lawsomepodcast. Be sure to leave us a review and rating in iTunes or wherever you find the you listen to. Until next week, stay lawsome.